Tonight on Canton Confidential, a preview of what may be to come from the defense.
These are superficial wounds consistent with teeth marks.
Your Honor, I'm asking that the witness be excluded from testifying at the trial.
While the jurors were at home, an expert witness was brought in.
I found a violation of Rule 14.
I take offense at the court's tone, and I just don't think exclusion is appropriate.
Whether or not they testify is up to the judge.
I think you have an uphill battle on that part, Mr. Jackson.
So, what could this mean for the trial ahead? We break it all down right now on Canton Confidential, the Karen Reed murder trial.
Today marks 50 days since opening statements. 50. Thanks for joining us tonight. I'm Glenn Jones.
I'm J.C. Monahan. Today, court was held without the jury. 3 potential witnesses were vetted by the judge in a process known as voir dire. They included a dog bite expert and 2 independent accident reconstructionists hired by the Department of Justice and the FBI. Now, whether or not they're allowed to testify before the jury is a decision that Judge Cannone is expected to make on Thursday.
Our Kirsten Glavin joins us live outside Norfolk Superior Court in Denham with some of the other big moments from today. Kirsten.
Yeah, today we got a glimpse as to what potential testimony may come from the defense side, only if the judge allows it.
Good morning, counsel.
First on the stand Tuesday in the Karen Reed murder trial, Dr. Marie Russell, a retired emergency physician and forensic pathologist, who the judge says was brought in as a witness late, leading to a potential discovery violation.
What we're here to do today is decide a remedy for this violation.
Dr. Russell explaining her lengthy career in medicine and in the coroner's office in Los Angeles County, adding that she's reviewed hundreds of dog bite cases in her career, even authoring books on them.
Those injuries appear to be consistent with an animal attack.
She's expected to testify that John O'Keefe's arm injuries are consistent with bite and scratch marks from a dog.
Down here, closer to the wrist, we have an unusual pattern of at least 4 striations, the way I see it, at least 4 striations that I believe are caused from the teeth towards the front of the mouth, near the arch.
The Commonwealth filing a motion to exclude her as a witness. Also on the stand, 2 accident reconstructionists from a company called ARCA.
What specifically were you asked to do?
So the agency that retained us gave us a selected quantity of file material related to this case and essentially left it as an open-ended question. Ultimately, was the evidence consistent with a pedestrian interaction between Mr. John O'Keefe and the Lexus?
Both potential witnesses saying they were brought in to examine if O'Keefe was struck by Reed's vehicle.
I was tasked from the biomechanical standpoint to determine or see if it's possible to determine how the injuries in this case occurred.
Making a point to say they were hired independently by federal investigators.
Who selected that information?
As far as I'm concerned, it would be the Department of Justice and the FBI.
Afterward, outside of court, Karen Reed sharing her thoughts on the trial so far.
It's smoke and mirrors, and it's going through my private life and trying to contrive a motive that was never there.
Now, Judge Beverly Cannone has not made any decisions just yet. Now, tomorrow there is an off day because of Juneteenth. So the jurors will be brought back on Thursday to continue with testimony. We're live here in Dedham. I'm Kirsten Glavin. Back to you, JC and Glenn.
Okay, Kirsten, thank you. That means we'll see you on Thursday.
And we are joined now by Michael Coyne, Dean at the Massachusetts School of Law. We're going to start with the beginning, which is the jury wasn't there, and that's because it's a voir dire. I toss it to you. Explain to us what a voir dire is.
Sounds Latin.
It's actually French.
Oh, there we go.
Voir dire.
Unlike most legal terms, which are found in Latin. What it is a pretrial, or in this case now, a trial ruling on the admissibility of evidence. What the judge wants to know is there an adequate foundation that can be laid when the jury's there such that we can trust this evidence and it's sufficiently reliable. She doesn't want them hearing about all of the information if, in fact, the ultimate conclusion isn't going to be admissible. So this is a ruling on, or will be a ruling on, whether that evidence ultimately can be heard by the jury.
And that is because, I'm sorry, that is because we didn't know about these witnesses. Is that correct? Because we don't do a voir dire for every witness. We've had, 50 days of testimony. But in this case, they were late to the table, right?
The dog expert, the one from L.A., is late to the table. And the reason they had that hearing is a question of a Rule 14 violation. Did they adequately disclose the presence of that witness in time? Trials are supposed to be a search for truth, not trials by ambush. And that's what the Commonwealth was saying, is this witness was disclosed to us far too late. There's no report. Typically with an expert, you provide the report to the other side so that they can start their cross-examination and their research on it. And so what they feel is that this was unfair surprise. On the other set of witnesses, the crash reconstruction people, they've known about them for a long while. That was part of the investigation by the federal government. They've had that report, which was exchanged from the Commonwealth, from the defendant to the Commonwealth. But it's, again, an odd set of circumstances because they've never talked to the defendant's lawyers. They haven't been paid by the defendant's lawyers. And again, it's odd that the experts, you don't have more information on them. And that's what the judge wanted to know. Are they sufficiently qualified? What is the basis for their evidence? How did they arrive at it? What did they look at? And so that the Commonwealth would have access to that information.
All right, let's go back to the first witness you were just talking about, the one who is potentially a Rule 14 violation. One of the reasons for that is because this witness actually made themselves known to the defense as opposed to the other way around, or at least the way it was explained in court is that it was through an intermediary. Here's a piece of that part of the testimony.
So who contacted you about this case?
I contacted a district attorney that I had worked with in the past. I had heard that there was a controversy, that there's some certain wounds could have been a dog bite versus perhaps inflicted by a motor vehicle.
Now, this first instance, when you say you heard about it, how did you hear about it?
Well, I believe it was via a headline that I received in my email from the Boston Globe headline. It was some kind of there was some kind of interesting case.
So it feels awkward that a pathologist will raise their hand, someone the defense doesn't know, and says, "Oh, I know what that is. I can help you out here." So what should we take away from what we just heard?
What you said, it's odd that someone would interject themselves into the case when they're a stranger to it. So that is really the question is, does she have a fascination with this case and somehow wanted to be part of it? That's what Judge Cannone, I think, in part was worried about. Or on the other hand, does she have valid information that came to light late, but nonetheless is important to the defendant's rights to a fair trial? Judge Cannone will have to make that decision. I think she's likely to allow her to testify in some fashion, restricting her ability to go as far as the defendant would have liked, though.
Yeah, there was a little bit of heat with Jackson and Judge Cannone today. Can you just talk about, there was a line he said something about, I don't like the court's tone.
Well, she had started the hearing out by saying that they have violated Rule 14, which is both an ethical obligation and a rule of court that requires lawyers to exchange information. So the trial is not a trial by ambush. You have the information, you can prepare, and then ultimately you can introduce that to the jury and they can determine what the truth is and whether it's credible.
And he was offended by that accusation.
Most lawyers would be, because if they truly weren't part of hiding the evidence, they would find that that impugns their integrity. And so if, in fact, they turned it over as soon as they knew, then there shouldn't be a mark on his ethical behavior. He rightly feels that he turned it over as soon as he knew about it, and therefore he shouldn't be castigated for producing the information because it's valuable to the defendant.
Can we talk about how if she is allowed in as a witness, Judge Cannone said to the prosecution, we'll give you time to find somebody who can refute what she's saying. This has been a long trial. So if they let her in, this could potentially extend it, at least because the prosecutor Lally couldn't say how long it would take him to find somebody.
Yeah, no, that again is a problem when we look at the length of this trial. If he has to prepare for the witness period, and that may take him, as he pointed out, about a week. But also then if he has to go out and find another expert to say that this expert is wrong, then and call that witness in rebuttal, now we're probably extending this well into July, and that is really problematic. But he feels that he got this information late, couldn't have prepared for it earlier. She wants to be fair to both sides. And she may also be sort of holding that carrot out to the defendant, saying, well, if you really call her, we're going to extend it another couple of weeks potentially, and they may well be done with this case as well. They may feel pretty confident about their case.
We just have a little time left, Michael, but I thought maybe you could underscore the importance of this piece of evidence, the injuries on John O'Keefe's arm. That is what Dr. Russell would testify to, saying that it came from a dog bite or dog scratches, whereas the prosecution has a completely different theory.
Yeah, both of these sets of witnesses today were vitally important to the defendant's defense. The dog bite expert says that, in essence, those are dog bites, not scratches from her car. Her car, in essence, then didn't come in contact with them. And that also leads credence to the defendant's argument about the third-party culprit, that someone else was responsible for beating him up and then dragging him to the front of the street where Chloe bit him, or Chloe bit him inside. There was a fight, there was a skirmish, and then they dragged him to the outside of the edge of the property. It supports the defendant, and so does the reconstruction. The reconstruction is significantly helpful to the defendant with respect to those experts.
All right, these are a big deal. Michael Coyne, thank you very much.
Thank you.